All right. What am I reading about? Let's see. Duties to opponents when acting as an advocate. Evidence and witnesses. Opponents' access to evidence. A lawyer must not falsify evidence or assist in perjury. Additionally, a lawyer must not unlawfully obstruct another party's access to evidence or unlawfully alter, destroy, or conceal a document or other item having evidentiary value. A lawyer is generally permitted under the law to temporarily retain evidence for a limited examination to prepare for the client's case. For example, to conduct tests as long as doing so will not materially alter or destroy the evidence. California note. The California rule also specifically prohibits a lawyer from suppressing evidence that the lawyer or the lawyer's client has a legal obligation to reveal or produce, advising a person to hide or flee the jurisdiction for the purpose of making that person unavailable as a witness. Those are the two prohibitions in this section 8.1.1, opponents' access to evidence. Next page, 8.1.2, advising a person not to give information. A lawyer may advise a person to refrain from voluntarily giving information to an opponent or other party, but only if the following conditions are met. 1, the person is a client or the client's relative, employee, or agent. And 2, the lawyer reasonably believes that the person's interests will not be harmed by not volunteering the information. California does not have equivalent rule. Paying witnesses. A lawyer must not offer an inducement to a witness that is prohibited by law, and it is generally improper to pay a witness for their testimony. The following payments to witnesses are generally allowed: reasonable travel and incidental expenses, compensation for loss of time or attending and testifying, reasonable fees to expert witnesses. However, such payments must never be contingent on the contents of the testimony or the outcome of the case. Court process. 8.2.1, abusing discovery procedures. A lawyer must not make a frivolous discovery request or fail to make reasonable efforts to comply with a legally proper discovery request made by the adversary. California difference. California does not have an equivalent rule. In fact, the comments to the California rules that a violation of a discovery rule or statute does not necessarily constitute an ethical violation. 8.2.2, violating court rule or order. A lawyer must not violate a court rule or order. However, a lawyer may openly refuse to obey for the purpose of making a good faith challenge to its validity. 8.2.3, using threats to gain advantage in civil case. While representing a client in a civil dispute, meaning an actual or potential lawsuit, a lawyer must not threaten to present criminal, administrative, or disciplinary charges for the purpose of gaining an advantage for the client. Note that if the lawyer believes in good faith that the adversary is engaging in illegal or unethical conduct, this rule does not prohibit a lawyer from stating that they will present charges if the conduct continues. Nor does this rule prohibit actual reporting of the violation. Special duties of prosecutors. Duties with respect to its own case. A prosecutor in a criminal case must refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. Make reasonable efforts to assure that the accused has been advised of the right to counsel and has been given reasonable opportunity to obtain counsel. Not seek to obtain from an unrepresented accused a waiver of important pretrial rights, such as the right to preliminary hearing. Make timely disclosure, this is fourth, Fourth, make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigate the offense, unless the prosecutor is relieved of this responsibility by a protective order of the tribunal. Note that this ethical duty exceeds the constitutional Brady obligation, requiring disclosure regardless of admissibility or impact on the outcome. Exercise exceeds it? Exceeds. Okay. Exercise reasonable care to prevent investigation or other persons assisting the prosecutor in a criminal case from making an extrajudicial statement that the prosecutor will be prohibited from making. I might have just lost my place. Okay, no. And not subpoena a lawyer to present evidence about a client unless the prosecutor reasonably believed that 1, the information is not privileged, or 2, the evidence is essential, and 3, there is no reasonable alternative. California does not include the restriction on subpoenaing lawyers. Duties with respect to any case. New, credible, and material evidence must disclose when a prosecutor knows of new, credible, and material evidence creating a reasonable likelihood that a convicted defendant will not commit did not commit the offense. The prosecutor must promptly disclose the evidence to an appropriate court or authority. If the conviction took place in the prosecutor's own jurisdiction, the prosecutor must promptly disclose the evidence to the defendant and make reasonable efforts to cause an investigation. Clear and convincing evidence in own jurisdiction must remedy. When a prosecutor knows of clear and convincing evidence establishing that a defendant in the prosecutor's jurisdiction was convicted of an offense that they did not commit, the prosecutor must seek to remedy the conviction. Trial publicity, Section 8.4, a trial is connected with a case or any associated lawyer in the firm or agency must not make any extrajudicial statement that the lawyer reasonably should know, 1, will be publicly disseminated, and 2, will have a substantial likelihood of materially prejudicing the case. However, certain dry facts about the case are permitted, and there's a chart that's going to follow. For right of reply, a lawyer is permitted to make a public statement that a reasonable lawyer would believe is required to protect a client from the substantial undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. For example, if the other side gave a press conference and said something prejudicial about the client, the lawyer can respond with a clarification. Here's your trial publicity chart on PDF page 83. In the PDF, it's page 71. So permitted references are on the left, and references likely to have a prejudicial effect are on the right. So what's permitted? The claim, offense, or defense is involved. Information containing the public record. This is for civil and criminal. And then there's, at the lower end of the chart, there's just criminal. Information contained in the public record, that an investigation is in progress, scheduling or result of any step in legislation, request for assistance in obtaining evidence, and a warning of danger concerning the behavior of a person that is, if there is a likelihood of substantial harm to the individual or the public interest. All of those are permitted in civil and criminal cases. What's permitted in criminal? The time, fact, and place of an accused arrest, the identity of investigating and arresting officers or agencies. What's not permitted in a criminal case? The fact that a defendant is charged with a crime unless accompanied by an explanation that he is presumed innocent. Any opinion as to the guilt or innocence of the defendant or suspect in a criminal case. In both criminal and civil cases, what is reference that are likely to have a prejudicial effect include the identity of witnesses or the expected testimony of a witness person. party or witness. Statements relating to character, credibility, reputation, or criminal record of a party, suspect, or witness. Third, the identity or nature of physical evidence expected to be presented. Fourth, the performance or results of any examination or test, or the refusal of a person to submit to examination or testing. And last, information the lawyer knows is likely inadmissible at trial and creates a substantial risk of prejudice. That ends the duty to the opponent. Part 9 is duties to non-clients. We have just learned about the client's duties to the court and others when acting as an advocate. This module covers a lawyer's dealings with people who aren't clients, including opposing counsel, adverse parties, witnesses, and anyone else the lawyer talks to in relation to the representation. Truthfulness and fairness are at the core of these rules. 9.1 Truthfulness in statements to others. No false statement of material fact. A lawyer must not make a false statement of material fact to a third person in the course of representing a client. However, puffery is allowed, and it is not considered a statement of material fact. Puffery includes estimates of price or value and estimates of a party's intentions as to the settlement. Disclosing material facts to address client's crime or fraud. A lawyer must disclose material facts to a third person when necessary to avoid assisting the client in a crime or fraud, unless the lawyer is forbidden to do so by the ethical duty of confidentiality, which will often be the case where the duty of confidentiality prevents the lawyer from disclosing material facts, and where continued representation would require the lawyer to assist in the client's crime or fraud. The lawyer must withdraw. Communicating with a person who is represented by counsel. In the course of representing a client, a lawyer must not communicate about the subject of the representation with the person they know to be represented by counsel in the matter, whether or not they are a party to the matter, unless 1. A party's counsel has granted permission, or 2. The lawyer is otherwise authorized by law or court order to make the direct communication. Note that this rule does not prohibit 1. Conversations on topics unrelated to the matter, or 2. Communications between the parties, and the lawyers can advise their client on such communications. California difference. The California rule does not prohibit a lawyer from communicating with a public official or public entity. Section 9.2.1 Application of Rule to Represented Organizations. The rule above also applies to represented organizations. The lawyer must get the consent of the organization's counsel before communicating with the current employee or other constituent of the organization who falls within the following categories. So, represented organizations, what we're talking about. A lawyer must get the consent of the organization's counsel before communicating with the current employee or other constituent of the organization who falls within any of the following categories. The person supervises, directs, or regularly consults with the organization's lawyer concerning the matter. The person has authority to obligate the organization with respect to the matter, or the person's act or omission in connection with the matter may be imputed to the organization for purposes of civil or criminal liability. Note, however, that if a person has their own counsel in the matter, then consent from the person's counsel is sufficient. California difference. The California rule does not refer to the first and second categories listed above, but similarly provides that the rule applies to any current officer, director, partner, or managing agent of the organization. It also applies to the third category of constituents listed above. Despite this difference, the end result is generally the same under both sets of rules. The prohibition will apply to high-level employees and employees whose conduct is at issue in the matter. Former constituents of the organization, Part A under this section, Consent is not needed before talking with a former employee. However, when talking with either a present or former constituent, a lawyer must take care not to violate the organization's legal rights, such as the attorney-client privilege, meaning the lawyer should not ask the former employee about any privileged conversations they had with the organization's attorney. Communicating with an unrepresented person, Section 9.3, when a person doesn't have counsel of their own or the person is represented, but the lawyer has no reason to know that, a lawyer representing a client may communicate with such person directly about the matter. However, such communications are subject to the following restrictions. 1, the lawyer must not state or imply that they are disinterested. 2, if the unrepresented person misunderstands the lawyer's role, the lawyer must make reasonable efforts to correct the misunderstanding. If the person's interest conflicts with the client's interest, the lawyer must not give any legal advice except that the lawyer may advise the person. The California rule is generally the same, but additionally provides that when communicating with an unrepresented person on behalf of a client, a lawyer must not seek to obtain privileged or otherwise confidential information that the lawyer knows or reasonably should know the unrepresented person cannot reveal without violating a duty to another, or which the lawyer is not otherwise entitled to receive. 9.4, lawyer as third-party neutral. A lawyer who serves as a third-party neutral must inform unrepresented parties that the lawyer is not representing them. Where the lawyer reasonably should know that a party does not understand the lawyer's role, the lawyer must explain the difference between the lawyer's role as third-party neutral and the lawyer's role as one who represents the client. For example, lack of attorney-client privilege when the lawyer is acting as a third-party neutral. 9.5, acting as advocate in legislative and administrative proceedings. Lawyers sometimes appear before legislators, city councils, executive agencies, regulatory boards, and other groups that act in a rulemaking or policymaking capacity. If the lawyer is representing a client in connection with an official hearing or meeting of the government agency or legislative body at which the lawyer or client is presenting evidence or argument, the lawyer must disclose that the appearance is in a representative capacity but need not disclose the client's identity. Additionally, the lawyer must generally act as if they were in front of a court. For example, they must not offer false evidence, make false statements, attempt to improperly influence the decision makers, obstruct access to evidence, and so forth. Section 9.6, respect for rights of others. Okay, this is going to be essentially the last page in this section. Receipt of documents or electronically stored information sent by mistake. When a lawyer obtains such a document or electronically stored information relating to the representation of a lawyer's client, and when they know of reason or reasonably should know that it was sent by mistake, they must promptly notify the sender so that the sender can take protective measures. California differences. The California rule is different in the following respects. It only applies when the receiving lawyer knows or reasonably should know that the writing is privileged or subject to the work product doctrine. And secondarily, in addition to notifying the sender, the receiving lawyer must refrain from examining the writing any more than is necessary to determine that it is privileged or subject to the work product doctrine. The comments also indicate that the receiving lawyer should either return the writing to the sender, seek to reach an agreement with the sender regarding disposition of the writing, or seek guidance from a tribunal. Note, if a document was sent intentionally, the receiving lawyer is free to mine the metadata. Heavy-handed tactics in representing a client. A lawyer must not use means that have no substantial purpose other than to embarrass, delay, or burden the third person. Additionally, a lawyer must not use methods of obtaining evidence that violate a third person's legal rights, for example, attorney-client privilege. California difference. California did not adopt this rule due to concerns that it is too broad and would not be interpreted in a consistent manner. So we're now on PDF page 90, and Within the PDF, page 78, the section 10 is titled Communication about Legal Services.